Bar question in remedial law. Paulin and Regine had a dispute over a 500 square meter parcel of land that they inherited from their deceased parents, Milka and James. During the barangay conciliation proceedings, both Paulin and Regine agreed to partition the lot in equal shares. As a result, the title to the property was cancelled and new titles were issued in favor of Paulin and Regine as to their respective lots. However, Regine discovered that the lot covered by her title was on the eastern portion rather than the northern portion, contrary to their agreement. Hence, Regine filed a petition for annulment of transfer certificate of title and barangay partition, with prayer for judicial partition of the intestate estate of the spouses Milka and James against Paulin. After trial, the court rendered judgment in favor of Regine. Paulin then consulted a newly minted lawyer, Attorney Terry, who explained to her that there was a misjoinder of causes of action when Regine included both annulment of TCT and the barangay partition, as well as judicial partition in the petition. Hence, the trial court erred when it ruled on both causes of action instead of dismissing the petition of Regine. Is Attorney Terry correct? Explain.
Answer: no, Attorney Terry is not correct. Under Rule 2, Section 5 of the Rules of Court, a misjoinder of causes of action is not a ground for dismissal of an action. Regine's inclusion of both the annulment of TCT, barangay partition, and judicial partition in her petition does not warrant dismissal. The court can address all causes of action in the same proceeding. Hence, Attorney Terry's assertion is not correct. The trial court did not err in ruling on both causes of action in same proceeding. AI explained.
Rule 2, Section 5 of the Rules of Court states that a misjoinder of causes of action or of parties is not a ground for dismissal of an action. Parties may be dropped or added by order of the court on motion of any party or of its own motion. Causes of action may be separated for convenience, avoidance of prejudice, or expedition of the proceedings. Additional notes. It is important to note that the court may still order the separation of causes of action if it finds that it is in the best interests of justice to do so. For example, the court may separate causes of action if they are factually unrelated or if they would prejudice one of the parties if they were tried together. If the court orders the separation of causes of action, each cause of action will be treated as a separate proceeding. This means that each cause of action will have its own pleadings, discovery, and trial.
If you want more, make sure to subscribe so you never miss a video.